So what we do is tort against property, which is chapter 6, and then chapter 7 we have very good. So now tort against property and unintentional torts. In unintentional tort part, we have a lot of sections from Motor Vehicle Act as well. That is the reason I wanted the session to happen today, because this is an important part. So tort against property. So basically the definition of tort against property is any tort which happens against property which which is a legal wrong that interfere with the individual's right to own, use, or control their property. So anything which is avoiding them or stopping them from owning, using, or controlling their property, which is the property might be both real and personal. So what is real property in terms of tort is the land, the building, the immovable property, and the personal means the movable properties, car, etc. So any such tort which is against the property is called which is interfering with the individual's right to use them, own it, or control them is a tort. So understanding basically that these torts are very crucial and separated for the purpose, especially for the property, because property is a big subject. So if in this property, for that, it is given a specific and a special one for the sake of property only. A chapter has been given for in tort. Now, tort can arise from such torts can always, or any tort can arise from intentional or negligent action also, which can infringe upon anybody's rights. So the very first topic is trespassing to land. So we all know by definition the trespassing to land occurs when an individual or individuals enter anybody else's property without permission, either intentionally or negligently. You're not supposed to enter anybody's property without their permission, or you do it intentionally, unintentionally, does not matter. So what are the key elements of trespassing of land? The key elements are unauthorized entry. So very first thing is unauthorized entry is the first characteristic, which is a key element. Then any physical intrusion onto the land. So physically, if you go intrude the land, that is unauthorized entry, or regardless of intent to cause harm, if you do. So if there was an intent to do it, there was not an intent to do it, does not matter. It is only limited to the scope where unauthorized entry act has happened. So it has happened, you have done it intentionally or unintentionally, it does not matter. To have an unauthorized entry, you just need to walk into that part of the land. So the trespasser does not need to have a malicious intent. They need not to have a malicious intent. The mere act of entering is sufficient. This is similar to what we have in various other laws also, where a malicious intent is not required. Only the act is required to violate the law. For example, for the trademark laws also, if by chance you have made a trademark which is similar to the other one which is registered also, you're using it also, but then it is not required as per the Trademark Act to have any malicious intent to do so. You might not be really aware of that. It has happened. But then still it's a violation of the trademark laws. Very same way, the trespasser does not need to have malicious intent. Sometimes, kids go ahead and they go in for, uh, breaking the boundaries and jumping inside to play or do something. Similarly, adults also do the same thing sometimes just for the fun. And that is where the trespass happens. So if a neighbor is walking out in your property without your permission to retrieve anything, maybe their dog has come inside, maybe a ball has come inside, that is also a trespassing. Although people do not consider it, but it is also trespassing. A contractor sets up a equipment on land without the owner's consent. So there is some work going on. The land is next to that work going on, and then the contractor of the road or the place goes ahead and places his machineries and other equipments or materials on the land without owner's consent, this is again a trespass. Or you have a building which is taken, which you have bought, and the builder who has made the building has left a lot of equipments in the parking or other places of the society, and he is not removing it from the property, from the campus of the property quickly. That is again a trespass by the builder. So various case laws are there. The very first one I would like to mention for this is ENTIC, ENTICK, ENTIC, ENTICK, ENTIC versus Carrington, CARRINGTON, Carrington. It is a case of 1765, and this is considered a landmark case as a foundational reference for the property law. The fact is, John Entick, his home was searched by the government agents without a warrant or lawful authority, as they were looking for materials related to seditious publications. Now, the agents entered the property and caused damages while searching. So, they also caused a lot of damage to the property while searching. So, then the court ruled out in favor of Mr. Entick, emphasizing that the right to personal property against unauthorized intrusion, stating that even the government cannot arbitrarily invade private property without legal justification. But please understand, the laws are different in India. In case of sedition, the CRPC, which is the BNSS now, does allows the police with an instruction from the magistrate to just jump inside the house in case they want to have they have some kind of suspicion. Without even permission of magistrate, a police officer can get inside your house if he or she has a strong and reasonable reason to enter and rescue somebody. If somebody is, he supposedly believes somebody is rescued or some kind of drugs is inside. So those kind of narcotics cases. So there is little difference in what was the law in British law and now, but just for the understanding, this is one of the landmark judgment which was considered in the British era. Next case, famous one is Kelson, Kelsen, Kelson versus Imperial Tobacco Company, which is 1957 matter. And this gives a concept of trespass via airspace invasion. So Kelson owned a property whose airspace was invaded by smoke emanating from the chimney of the Imperial Tobacco Company's factory. So Imperial Tobacco is a very big tobacco company now also. So they're running a factory, and from there the chimney of the Imperial Tobacco Company's factory was entering the property of this person, Mr. Kelson. So he claimed that the smoke created an unpleasant environment that impeded his enjoyment of his property. So the court ruled in favor of Mr. Kelson, stating that the tobacco factory was liable for trespass because the smoke constituted an unauthorized intrusion into Kelson's airspace, and affirming the right of property owners to the vertical limit of their properties. So the property's vertical limit was also taken away. Just a small addition to this for knowledge. The vertical airspace is up to only few meters, where you have legal rights on the vertical rights of the property. Above and beyond that, it is the property of the government. So there are defenses also. So if we talk about trespass, we have been talking about defenses in all the other chapters. So there are some defenses also which you could take in case of your client has done a trespass and you believe it is not a trespass, or you want to prove it is not a trespass. So number one is consent, of course. If the property owner gives an explicit permission for entry for an activity, and then they cannot come back and call it a trespass later for any reasonable reasons. For example, you give a permission to somebody to have a program or a party in your land, and somebody does that party. You've given a permission from 9 a.m. to 10 p.m. The person, while finishing the party at 10 p.m., takes a reasonable time of 20-30 minutes to wrap out and go out of the property. In this case, you cannot put a 30-minute for those 30 minutes. You cannot be charged for trespass because that's a reasonable time needed to complete and move your articles within some point of time when you're allowed to be there on the property from 9 to 10. So consent in this case will help you, that there was a consent and there is a reasonable time it takes to wrap up. I just cannot vanish from the land at 10 p.m. It will take some time. So that is where in such scenarios, consent will help. Or there was a consent given by the previous owner of the property to use certain property for certain purposes, and then their next generation comes in and they put a charge of trespass against you. Then until and unless that contrary to that contract, there is something which is happening, you cannot be charged for a trespass. Second thing is necessity. So if an individual which enters the land to prevent more significant harm, for example, to escape a fire, this may provide a lawful defense to the trespass. So there was a necessity. There was a fire and you have to jump into that property and run through it. Or there was a dacoity happening or robbers have come in and you have crossed that place. Or there was a tsunami which has come and you have trespassing the place to just cross across the place and to safeguard your life and liberty. So then it is not a trespass. So if it's necessity, right necessity, it cannot be. Or you are a police officer who are chasing somebody, and in term of chasing that, you believe that the person has crossed that person, has crossed a certain boundaries, and this is the shortest path for you to cross. It's a necessity. It's a legal immunity as well. So these are the defenses are consent and necessity. Next topic is trespass to personal property. So by definition, the personal property occurs when a person wrongfully interferes with another's right to possess their movable belongings. So what is the key element? The interference must be mentioned. It has to be intentional and wrongful and impacting the owner's use, and the individual must have a possessory interest in the property. So trespass to the personal property occurs when a person wrongfully interferes with another's right to possess the movable belongings. So this is related to movable belongings. For example, borrowing a friend's laptop without permission and accidentally damaging it. That is a trespass to personal property. So what is the difference? You have borrowed the wrongfully or intentionally wrongfully impacting their use. So their use has been trespassed. So the difference between the trespass to land is you are physically entering into that place while you're not standing on the laptop. You have intentionally trespassed into the owner's right to use it. So if you borrowed the laptop is a very sweet language. What it meant is you have picked up the laptop from friend's table without his knowledge and gone ahead, used it and damaged it. You have not done a theft, but you're using it without his permission. Or keeping a neighbor's some machine after borrowing it or some article after borrowing it and refusing to return it when asked. Then again, it is a trespass. It's a trespass to personal property. So that is the difference between the personal property and the trespass to land. You do not physically enter into it, but you physically acquire it, prohibiting the person to use it. The case law example is Gloudon versus Bloom. Gloudon. Gloudon versus Bloom. Bloom. 1901. So this case is a critical predecessor for trespassing to personal property. So the plaintiff, Mr. Gloudon, he owned a horse that Bloom accidentally injured while attempting to capture it. So Bloom had tried to use a lure without permission. He tried to, without permission, tried to attract his horse and attract its attention and tried to hold it and tried to use it. So it was something which was his personal property, movable property, and which he was trying to intentionally trying to lure it, attract it towards itself to bring it towards himself. So the court found that Bloom is liable for a trespass, ruling that unauthorized interference with another's property and their uses to the property warrants a liability for damages. And that is what is covered under trespass to personal property. And naturally, the defense would be number one, consent. That owner allowed me, he has given me the property, the laptop or the horse to use. So there cannot be a claim for trespass, at least. Then second very important thing is due care. So a defense based on arguing that reasonable care was taken and that the interference was unintentional. So whatever done was unintentional. It just happened and I did not meant it to do it. And it was done in spite of my due care. You went to the friend's house, on the table you kept your bag, and while picking up your books and article, you put your his laptop also into your bag. You kept it very safely as you would have kept anything in your bag. By chance, you slipped on the road, the laptop was broken, then it's not a trespass. If you can prove it, it was not intentional, it's not a trespass. So that's a due care. You've taken a due care and it happened unintentionally. It was not something which was uh, uh, intentional, and you took due care. There was no reason you wouldn't have taken care. I mean, you broke two things also of yourself also in the back in the same time. So let's come to the next topic, third one, which is called detention and conversion. I'm just going a little fast in module 6, which is purely theoretical, and we have to go and into the sections of motor vehicle in the next one. So detention and conversion, please note if you have any questions. So detention and conversion. So detention are wrongfully, the name as it says, I mean, you must be aware in the criminal laws as well, the word is used. So wrongfully holding someone else's property without their permission. So in normal law, legal terms, detention means detaining a person. A body has to be detained wrongfully to consider the crime of detention. While as we are talking about tort, which is a civil matter, and we talk about properties here, we talk about the compensation here. So in that context, the detention means wrongfully holding someone else's property without the permission. So that is detention. Okay. So while the conversion, if we talk about a more severe form of detention, so it is a far more far more severe form of detention where one exercises control over another's property and effectively denies the owner their right. They have converted it to their own property. So detention is holding someone else's property without their permission, while conversion goes one step ahead where you deny the person to their right and do not return it also and do it effectively. Effectively denied means you put a lot of effort to deny that. So what is the key element? Key element in both the scenarios is the intent. So there must be an intent to convert or detain the property. You have an intention to do it, which has to be proved. And denial of ownership is something which is significantly interfere with the owner's ability to control their property, and you are doing it significantly putting efforts to that. So, for example, take example of detention. So a person borrows a book but keeps it indefinitely and does not return it when asked. That is detention. A tenant accidentally leaves a valuable item behind after moving out and the landlord sells that item without permission. So now he has converted it into his own property by selling it and converting it into a property. So it becomes far more severe. He's just not holding the property and denying it. He has consumed the property. So that is the difference between detention and conversion. Detention, as for the criminal laws also, is holding somebody. It's not if you detain somebody, you don't cut that person and cook the person and eat the person, right? The person is detained and kept in some place, secluded place mostly, and then the body is detained. So that is the case of detention in property also. But when you convert something, you convert it completely. So you have converted that interest in the property completely into yourself and you have digested it. So the case example is Moore, MRR, Moore versus Regents of the University of California. MRR, Moore versus Regents, Regents, Regents of the University of California, 1990. So this gives a complexity around the ownership and informed consent regarding biological materials. So in this case, what had happened is, this is a case of detention plus conversion. So Moore underwent a treatment for blood cancer. So he got a blood cancer treatment, which is leukemia, during which his donor harvested, doctor harvested Moore's cells without his knowledge. So his cells were taken out and were harvested without his knowledge. There was no consent taken, no information taken, given, and his cells were taken out for harvesting. Now, the cells were later used to create a lucrative cell line, a biological cell line for research and commercial purpose. So his cells were taken out and they were used to create a new kind of treatment, a new kind of research material and for commercial purpose. So then Moore argued that he should have a right over the cells which were taken from him, and thus claiming a conversion, because the other party has not only taken or detained his cells from his body, but also what they have done is they have also you converted it into commercials. They have started earning using his cells. So the court ruled that Moore did not have property rights over the cells after they were removed. It emphasized that the importance of informed consent and found that the unauthorized commercial use of his cells constituted conversion. So in that case, the commercial use of his cells constituted conversion, highlighting ethical issues in medical practices. So he just did not have property rights over the cells, but also he has a right over the converted money also. So it was a case of conversion, and it was one of the medical practices which were not right. So unethical medical practices. What could be the defense in case of such scenarios of detention and conversion? You've detained something and you have converted it. So what are the defenses? The defenses are claims of right. The defense where the party asserts that they genuinely believed that they had the right to retain or control the property in question. So they believed it is their property, and that is why they detained it or they have converted it. For example, some people were rearing some chicken in village, and all chicken look like same. So one person by mistake understands that this is the chicken from his farm. He picks up and keeps it with him, cuts it, sells it also. While it comes after reinvestigation by himself that it's not his but somebody else's. So what he did is was under pretext of or under understanding of a claim of right. So he thought it is his. So they genuinely believed that this chicken is coming from his farm, not the neighbor's farm. Or in good faith. This defense applies when the individuals acting upon a property believed they had a legitimate interest in it and did not intend to cause harm or deprive owner of their rights. So this is done in on good faith. They believed it is there and they have come into the property believing it's a legitimate interest. So the claim of right, where he claimed his right, that this is my right, there is no problem. I have claimed the right on this property, and or together in good faith also, where I had no intentions, malicious intentions. Coming to the next topic, module 6, chapter 4, point 4 is passing of injury to trademark, patents and copyright. So I think trademark I started talking at the start also, we'll continue here. So passing of injury to trademark, patent and copyright. So passing off is the pass of a kind of fraud where an individual misrepresents their goods or services, leading consumer to believe they come from another established brand. So that is passing off. Passing off uh, the fake goods as a genuine good. If we say, consider this in English statement. So passing off means passing off a fake thing to be real. So a form of fraud where the misrepresentation, through misrepresentation, their goods or services. It could be good or services both. They're leading into consumers to believe they come from another established brand. Second is injury to trademark. We talked. So injury to trademark involves unauthorized use of a trademark that creates confusion, creating affiliation or sponsorship. Now, this is very, very important because it does not really only means that somebody has used a trademark intentionally creating a copy of it, printing it and selling it, his articles. No, it might be the other person's trademark was also registered under trademark. The registrar of the trademark, as we say, he might got his trademark also registered with the same registrar of trademark, but from different geographical location. For example, one is one city in India, one is one state in another state in India. But while doing it, if the person who had a previous knowledge of such a design which is available with a product line which is similar to him and which is catering to the similar line of customers, or with all his knowledge, he goes ahead and designs a similar design, a similar logo, a similar trademark wording, and then he gets it registered with a certain different class of material. So every trademark has to be registered with different class of materials. So he goes ahead and gets it registered in some other trademark class. So for example, somebody registers in trademark class number 10 for one logo. Somebody registers under trademark category number 5, class number 5. With a similar logo, he has knowledge. And then he starts to wrap, pack, and sell the things in the same market, which is something which looks almost similar. So what is happening here is both of the parties have the similar kind of design, but legally both are on the place where both designs are registered by the trademark agency. They have not done any criminal activity. But still, in spite of that, there is a violation of the trademark, which could be challenged under trademark section 23. So injury to copyright. So unauthorized reproduction of public display of creative work that are legally protected. You might have seen a lot of videos which are used in the YouTube. The sound is paused because it's an unauthorized reproduction of public display of creative work that is legally belonging to somebody else, or a painting or a writing piece. So that is injury to the copyright. And patent also similar thing. Somebody else has patented something else, and you are either created something copying that design and you are selling it as yours. So what are the key elements for this passing of injury, trademark, patent, copyright, etc. is consumer confusion is created. So a primary focus is whether the consumer is likely to be confused about the source of good, service, or product. So there is a confusion in the minds of uh, customers which is created. Then goodwill. So goodwill is something which cannot be measured directly by any unit, but then it has a very important, very heavy impact on the business or the productivity of the parties where it is used. So, for example, if Britannia has certain product which has a very good goodwill in the market, when you go to the shop and you find Britannia biscuit, and then somebody is selling something called Britannia biscuit. So what he is trying to do is trying to imitate the packet of the design, the trademark, and the similarity in the name the person has picked up. And why he has done that? What is the reason? The reason is in name of Britannia, you might get confused with Britannia, which looks similar, sounds similar, the packaging is similar. You are using the goodwill of the other company and you are eating up into their profits. So every packet which you are selling, you are eating up into the goodwill of the Britannia company, and those many packets Britannia is making loss because you have put a hole into their profitability by using their goodwill. So there has been a goodwill associated with the trademark or the copyright, which is a very, very important thing. For example, passing off. For example, a company setting imitation perfume that closely resembles a well-known brand without disclosing they are fakes. So how do they disclose their fakes? They should have told, we are not part of so-and-so company, we are so-and-so places, we are made in India, and so this is not a French company. So imitation products are passing off. Trademark injury is a tech company, uses a logo that is nearly identical to an established company's logo. So somebody uses a logo which looks very much like IBM, and then the company goes ahead in the market. So what will happen is in this deception, a lot of consumer will be confused. They will sometime feel in their mind that, okay, this software which I'm downloading or this learning which I am taking, this coaching which we are taking from technical side is actually something which is coming from IBM Corporation. So that is a trademark injury. Or somebody is selling some product and which is a very famous product. For example, uh, the very famous case of glucovita versus glucovit, where the glucovita was a medicine which was produced in the US as a combination of glucose and vitamins, whilst glucovit was a biscuit manufactured in India. Now, the courts came back finally putting a judgment that by the name of Glucovit, which is very similar to Glucovita, which is a company which is selling glucose mixed with vitamins for people's health. Somebody might believe that this is something which is used in the Glucovit biscuit, and they're eating into the uh, goodwill and the trademark which they're using also, which is similar, and they're passing off that particular product as a real product. So copyright injury is also one aspect where a filmmaker, for example, use a popular song in a movie without asking a license agreement by the other producer or producing company which has actually rights on it, or something like that. So famous case law is Harley Davidson versus Harley, Harley, Harley Davidson, Davidson, Davidson versus Grottanelli, 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 2001. So this is a highlighting the need of protecting trademarks from unauthorized users. So Grottanelli sold merchandise featuring Harley Davidson's name. So the product was coming from Grottanelli company, but everywhere on the product, big images, logos, pictures were of Harley Davidson's name and logo, and they used it without permission, claiming it was an homage. They said it's a out of respect, out of homage, we are putting that. Harley Davidson argued that this misled the consumers and diluted their brand because Harley Davidson doesn't only sells the bikes or motorcycles, they also sell accessories and merchandise, which has to be used with the Harley Davidson bikes. So that Grottanelli company intentionally, in name of saying we are paying homage to the Harley Davidson and we are bhakt of Harley Davidson and we are putting their images here on all our product. No, it was just to mislead the company, the customers, and the court ruled in favor of Harley Davidson, emphasizing that the importance of trademark protection is very important, and concluded that the Grottanelli's actions was constituted passing off. They were not doing nothing but passing off. They are creating an imitation product which was being sold in the name of Harley Davidson. So what are the defenses? If you have committed this crime or your client has committed this crime, what defenses you will take? The defenses are fair use. The defendant may argue that the use of copyright material is allowed under the fair use doctrine, such as for criticism, comment, or educational purpose. So if you tomorrow go ahead and you publish couple of research paper on Harley Davidson, and you're putting on all your websites which is talking about Harley Davidson, your educational research on the various commercial aspects of Harley Davidson, they cannot come back and claim a copyright against you because the imitation is used for kind of educational purpose. And similarly for criticism or comment, etc., you can use it. There is no uh, trademark violation in that case. Second defense could be honest concurrent use. So if two businesses use similar trademark without knowledge of each other, their defense may apply, asserting that there was no intent to deceive consumers. They were similar. So mom and me and mom, they fought this matter for a very long time in the court. The same, but anyways, one of them lost. But uh, that was the defense given by them. So this is about passing off injury or to trademark, uh, patent and copyright, etc. Coming to point 5, which is public and private nuisance. So public nuisance is a conduct that impacts the general public or a community, causing them harm to public rights and interests. Public rights and interests both are harmed. While a private nuisance is action that interferes significantly with an individual's right to use and enjoy their property. So if it impacts public nuisance, then it's a public nuisance. If it impacts a private person, an individual, then it's a private nuisance. Now, what are the key elements for that? So substantial interference. It just cannot be just a very small interference for a very small point of time. The plaintiff must show that the defendant's action caused a significant disruption. So it has to be a substantial interference. When we say interference to the public and the individual, it has to be significant. And reasonableness. So the courts will also consider where the claimed nuisance is an unreasonable interference or a reasonable interference. So whether it be uh, it's a significant or insignificant, the very first thing which has to be considered is it unreasonable or reasonable? Was it supposed to, if it falls on the foot of being unreasonable, then probably even a non-significant disruption might be considered illegal. So the unreasonableness or reasonableness is also very important point. For example, public nuisance. A nightclub, they emit a loud noise and foul odors that disrupt the nearby residents areas, affecting the community's quality of life. For example, very famous bars in Baner, I think 5, 6 years back. There were a lot of bars in one building, and they had not followed the norms of making a soundproof environment. So what was happening is until night 11 o'clock, 2 o'clock, 1 o'clock, sometime 3 o'clock in the morning until that point of time on the weekends, there were loud noise, people shouting, dancing, making parties, and then loud music from the DJ and smells from the smoking area and alcohol that was coming to the next door neighbors, the buildings which were next to it. So then, with the same public nuisance, the matter was of that kind of matter was of a public nuisance, which was then considered and actions were taken. I mean, actually, there were also criminal aspect of it, which was also taken. But just giving an example, this is one of the public nuisance for which you can, when we are talking about tort, when studying tort, it means for us, what is important is the compensation. You've disturbed me for this mental harassment and whatever has happened. I need a compensation. And private nuisance, for example, a person's tree grows and encroaches onto their neighbor's property, so causing damage and interference with the neighbor's enjoyment. So the tree grows and the neighbor is asking, you cut it down, the branch is shooting to a window and it goes ahead and breaks the window and goes inside. So that is interfering their enjoyment. So this is a private nuisance. So famous case law is Ryland versus Fletcher. So RYLANDS, Rylands versus Fletcher. FLETCHER, Fletcher, 1868. So Rylands constructed a reservoir on his land that burst and flooded Fletcher's coal mine. Fletcher had not previously been aware of the reservoir. The flooding caused significant damage to Fletcher's coal mines. So the court ruled in favor of Fletcher, saying that Ryland was strictly liable for damage caused by his non-natural use of the land. I think we discussed this in the very day one also. So, which is this case was holding water in large reservoir. There was no reason he should have done that. This ruling established the principle that those who engage in potentially harmful activities are responsible for such damages caused regardless of their fault or intention. So, even fault they have done or not, or intention or not, does not matter. If a nightclub is creating nuisance, they never thought of creating a nuisance to the neighbors. They just wanted to have a good business. The more people come, the more people dance, the more people come, eat and drink. It's a good business for them. But it has caused a public nuisance in spite of they not actually planning for it. Next case law is Broughton versus Holyoke. So Broughton, 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 Broughton versus Holyoke, Holyoke, Holyoake, same one word, Holyoake. It's a matter of 2000. So this is one of the matter which examine whether the gathering for religious purpose also could constitute a nuisance, which is a very hot topic sometimes in the social media where we talk about the loudspeaker use, etc. So neighbors complained about loud noises and disruption from religious meetings held at a nearby location. And the noises and the activity were regular and disrupting the peace of the surrounding people. People were having difficulties to work, sleep, etc. And it was a constant noise for them. So one man's music could be other person's noise also. It depends completely upon the personal preferences. That's where the legal principles work. So the court found in favor of the plaintiffs, concluding that the noise created by the gathering constituted a private nuisance due to its substantial interference with the neighbors' enjoyment of their properties. One of the enjoyment is they want to have a peaceful abode in the property, which was violated. Then, when this is this is happening, this kind of nuisances, what could be the defenses? So, defenses is coming to the nuisance. If a plaintiff moves into an area known to an affected by a nuisance already, they may be barred from claiming nuisance because they accepted the conditions when they arrived. Now, if there is a club, which is a sports club, which is a cricket club or football club, which was already prevalent in that area. Two, three clubs are next to each other, and then you come and buy a adjoining land, which is a private land, and you buy and you make a house, and then you now cannot come back and claim a nuisance from the companies because it was an established brand, a big stadium there where people would come, and there would be noise during day and night, and there might be sometimes spectators also shouting, clapping, cheering. So you just cannot come back and claim a nuisance because you have come to the nuisance yourself. So this is first defense. Second defense is reasonableness of the use. So the defendant may argue that their conduct was reasonable under the circumstances, asserting that their activities did not substantially interfere with the plaintiff's use of their property. It was reasonable under then the person is oversensitive. For example, if you are in a house where next door neighbor comes and complains about some music and some dance practices, and reasonably twice or thrice a week you are doing some Kathak or some Bharatanatyam practice at the home with your teacher, it's a reasonable use of your house. You also have a right to go back and use the house for your own purposes. Where would you go and do your dance practices? On the street? No, you will do it in your house. You have also brought the house for your purposes. So nobody can come back and claim of a nuisance that you do dance practice twice or thrice. Okay. If you're doing it in mid of night and dancing on the head of the people, then it is unreasonable. But during the wee hours of the day, when the time of the day, morning to evening, is constituted reasonable for the practice and the teacher comes and teaches, it is reasonable use. So reasonableness. So two kinds of defenses are there for nuisance. One is you have yourself coming to the nuisance. You have yourself put forward yourself to the nuisance, and then reasonableness of the use. Tomorrow somebody buys a house next to the bus stand, and the person comes back and files a case against the that bus stop saying, "Boss, I'm getting disturbed." You cannot claim because you have made a house near a bus stop. You will hear the sound, you will hear the loudspeaker, you will hear the announcements. So now let's see again under point 6 the particular defenses available for each kind of things. So uh, various defenses can be invoked across different property torts, and the application of these defenses often depend upon specific circumstances surrounding each case. So defense always in any case, whether it's a tort, criminal, civil, whatever it is, it's a general thumb rule that the defense is mostly depending upon specific circumstances surrounding each case. It will be always little bit different here and there. It cannot be same for all. In similar cases also defenses might be little here and there. So common defenses across tort is consent, which we have seen, which is mostly consent, which is a party which has already have a consent and they have invited the problem on their head, they cannot come back and call it's a tortious activity. Necessity is something which we talked. If for necessity somebody has to do, it cannot be considered a tort. If somebody is claiming a right or in good faith somebody is doing it, it cannot be considered a tort. Or if somebody is knowing that it is a nuisance or reasonable, somebody is reasonable. In that case, if somebody comes and claims a tort, it cannot be a tort. Now we move to chapter 7, which is unintentional torts. Hmm? So there are many unintentional torts. We talked about it earlier about the motor accidents. Nobody comes out of the street to have a accident. So the very first one is product liability and defenses around that. So product liability refers to the legal responsibility that a manufacturer or a distributor and a seller holds for injuries caused by defective products. So this legal framework ensures consumers are protected from harm resulting from defective goods while holding business accountable for their product. So this law is ensuring that you have that business, you are earning from it, you are one who's making a promise, and then you are also not fulfilling the promise, and because of you, I have got some kind of physical or mental damages for which we can come back and claim a defense. So that is the product liability in terms of when we talk in terms of the product which might harm me and cause an injury, then it's a specifically that tort is called product liability related tort. So the types of product defects could be uh, number one, design defect. Number two, manufacturing defect. Number three, marketing defects. So let's see one by one. So when we talk about design defects, let's take an example. So a manufacturer designs a children toy with small detachables, very small detachable part that poses a choking hazard. There is a chance if you're making a children's toy, children's are small kids we are talking about, they have a tendency of putting everything in their mouth. So with small detachable things, if you're making, there's quite a chance a child will pick up and choke on it. So when a child chokes on one of the parts and suffers injuries, the manufacturer may be held for failing to consider the inherent risk in the toy's design. So this was a design defect. Or a car is designed without adequate crush zones in the collision. So, for example, there is a nowadays a requirement internationally for a crush zone in the car. So, when you have a car, when you open the bumper now and see from the older cars, you will see all the machineries in the car, the engine, everything used to touch the brim of the first front side of the car from inside. It is no more the case. You have some gap which is always crush zone which is kept free so that when a crush happens, an accident happens, it crushes and gives some cushioning, some time to recover from the accident. It slows down the vehicle. So a car is designed without adequate crush zone in a collision. And then in a collision, it leads to a increased injury. So if a crash results and severe injury happen because of this design flaw, individuals injured in the crash could claim that the manufacturer is liable because of design defect or maybe some other designs which were not right in the machine which have caused a lot of issues to the people. So that is something which is a design defect. Now, the famous case laws in this regard for design defect is uh, grave man. I don't think a special spelling is required. Grave man, one word, versus Van Pelt. Van, one word, V for victory, A-N Van Pelt, P-E-L-T, Pelt. 2001, the court ruled that the manufacturer is liable due to a design defect in a product that can cause injury, stating that the product's design failed to meet safety standards expected by the consumers. So this was one of the case laws where a design defect of the product caused injury and the court ruled in favor of the consumer. Second one is Barker, B-A-R-K-E-R, Barker versus Lull Engineering Company, Lull Engineering Company, 1978. The court determined that the lack of safety devices on machinery constituted a design defect, leading to workplace injuries that warranted compensation. So there wasn't enough safety devices or safety mechanism which was part of the machineries which were supplied in the for the use of the in the day-to-day use in the workplace, and that had caused a risk and injury to the people, and this was warranting compensation. So design defect is something in nutshell which is a manufacturer's design which is which was supposed to be done with due diligence has not been done, and adequate measures has not been taken, which might have caused an injury to people. And once injury happens, those compensations could be recovered under the design defect of unintentional tort. This is a tort which is unintentional, but then one of them is product liability, and under product liability, this is the design defect. Coming to the next one is manufacturing defects. Now, a batch of energy drinks, for example, is bottled with a toxic chemical due to a factory malfunction. When consumer becomes ill after consuming the drink, the manufacturer can be held liable for the injuries resulting from the defect. Or a batch of car tires is manufactured with faulty rubber or faulty metal wires, leading to blowouts of the tires at the high speed. If an accident occurs due to the failure, the parties can claim product liability against the tire manufacturer. So this defect is why? Because the design was fine. There was no problem with the design of the tire or the design of the or the composition of the drink, which is the design of that drink. There was no problem with that. But when it was manufactured, there were defects which was arousing because of the manufacturing not done properly or some defect in the manufacturing. Now, it is not something which is intentional, or it does not matter is it intentional or unintentional. If it happens, it happens. and the company is liable for the manufacturing defects. Case law. So Hoffman versus Greyhound Lines. Hoffman, 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 one word, versus Greyhound, 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 one word, Lines, Inc. 2001. The court determined the liability based on manufacturing defects when a defective bus part caused a serious accident. So this was a bus accident which happened because of a defective bus part, and it was ruled against the manufacturer of the bus, saying because of your defective bus part, there was a critical accident which has happened. Next case law is East River, East, one word, River, another word, SS Corp. East River SS Corp versus Trans America, one word, Trans America, one word, Delaval, 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 Inc. 1998. So this was also somewhere where the manufacturer's defect has caused a severe injuries to people, and because of this defective part, the uh, the manufacturer was liable to pay. Now, another type of injury is defect is marketing defect. So, for example, a pharmaceutical company advertises a medication without including crucial side effects in their promotional material. So if a patient experiences severe side effects, they may sue the manufacturer for failing to provide adequate warning. So that particular warning has to be given that these are the risks. Or a children's toy is sold without clear instructions on safe use, resulting in a child's injury during play. So the parents could argue that the manufacturer was liable for not providing sufficient warning to the end user. So these marketing defects happen when you market a product, when you go ahead and promote the product, and you only talk about the good things. You're not talking about the risk around that. You're not talking about the safety precautions. All those things are not spoken about. So the very famous case law is Kitchen, Kitchin, Kitchen versus Robinson, 1970. This is where a toy manufacturer manufactured couple of toys which caused accidental injuries to the kids. And that's where one of the parents went to the court, and that the court established that the toy manufacturer is liable to compensate to pay compensation because they had not put any adequate warning, establishing that clear instructions were critical for product safety. It's very important to put a clear instruction, reasonable. Second case is Fitzgerald versus Cody, Fitzgerald, Fitzgerald versus Cody, Coady, Cody, 2011. So there was a product manufacturer who manufactured certain product, and the product caused certain injuries to people, while the manufacturer argued that it was completely safe to use, and there were safety measures also which has to be taken while using the product, and that has to be understood by the consumer. Then the court came back and said, you had not provided those instructions into your safety manual or with the product manual, which caused this accident. So you have gone back and you have put literature in the product about all the benefits that people could have, how to use it, but then you have not put all the safety what people have to take while using that particular product. So that is where the marketing defect comes in picture. Now, what could be the defenses against the product liability claim? So for all these things, what could be the product liability claims? First of all, assumption of risk. So if a consumer knowingly use a product, despite defects, they may not recover damages. So if there is a defect in the product, a consumer uses a flawed power tool that ignore warning about the defects leading into injury, they cannot claim a claim. Or if you have a car which is not working fine, there are tires which are not fully properly inflated, the brakes are not working fine, you know that, still you are using the vehicle instead of getting it fixed and then using it, then you cannot come back and claim to the car manufacturer saying this is your defective product. It's a defect in the product which is part of the daily uses, and in knowing that you have used it, which is something cannot be claimed under a tort, and that is what something which is comes under assumption of risk. You should assume that this risk is there if you're using it this way. If you're using a broken machine and you're trying to be, safe around that, and then you get injury, you cannot come back and claim the machine was defective. Whether there's a design defect, marketing defect, or whatever it is. Then, as a previous one chapter, it is contributory negligence. So if a consumer's negligence contribute to their injury, then this may also limit a recovery. For example, a customer modifies a device, removing safety features and sustains injury. The manufacturer may argue contributory negligence since the modification increases the risk. A user fails to follow the instruction of for a medication but takes it away. So certain medications are not supposed to take in together with certain things. For example, alcohol. And there is clear indication given in the medical literature also. Doctor has also told you. In spite of that, you have taken it, and then you suffer a side effect. You cannot come back because you have contributed to the problem. So that in this case, the manufacturer or the producer cannot be put under such kind of tortious claim. Next point is product misuse. If a product is made for something else and you're using it for something else, then you cannot come back and claim product misuse. Tort. For example, consumer uses a hair dryer underwater, resulting into an electric shock. Now, hair dryers cannot be used inside the water. They are intended to dry your hair. So the manufacturer is not liable for that. Or a person uses a power drill and tries to do something, uh, uh, tries to plays with it or whatever something he does it, which causes an injury. Or, for example, tries to mix dough in his house. So manufacturer cannot come and argue that, you cannot come back and say that it's a manufacturer's defect. It's you who has done a misuse of the product. So for misuse also, product misuse also, there is a famous case is Greenman versus Yuba Power Productions Products Inc. Greenman, one word, GREENMAN Greenman versus Yuba YUBA, one word. Next word, Power Products Inc. 1963, in which the court ruled that the manufacturers are liable for injuries caused by defects regardless of misuse, but also emphasized that misuse could significantly affect liability causes. So sometimes they say, in spite of misuse, the manufacturer is liable because the manufacturer might not have given a clear risk or danger hazard instructions. So if some machine could be very dangerous, the manufacturer might still be liable in spite of misuse. For example, in the case of a hair dryer only, if the hair dryer is given to somebody and if you pick up the pack nowadays, also you see it is clearly written, don't use in the wet condition, don't use it with the water, don't wet it and use it. Those things are written there. So in spite of not, it's a mistake from the manufacturer, the person has misused it, but then you have also contributed as a manufacturer by not helping people understand. You cannot consider everybody wise enough to understand what is electricity and how it can harm them, what is conductor, what is not conductor. So that is why it's a again manufacturer's responsibility in spite of misuse also, and this case law talks about the same thing. While if it is all fine, then there is a case law called Liriano, Liriano, Liriano versus Hobart Corporation, HOBART, Hobart Corporation, 2000 matter. The court found that the plaintiff's injury was a result of misuse of a meat slicer and reduced the manufacturer's liability by taking the misuse into account. So it was taken away. Now we'll go to the next part, which is negligence, duty to take care and its breach, foreseeability, causation, contributing negligence, and other defense of negligence, occupier's liability, res ipsa loquitur. So couple of them we have already touched upon. I'll just quickly go through those parts. I'll go through those parts quickly. So negligence is a tort that arises from when individual fails to exercise reasonable care. Somebody is failing to exercise a reasonable care and be negligent about it, which results into harm to another person, and the basis of Negligence claim is the duty to act in a manner that a reasonable, prudent person would under similar circumstances. We talked about the reasonable person, etc., on the day one. So, what are the key elements? Is duty of care. We talked about it earlier also in the previous session. So, duty of care. The legal obligation is to avoid acts that could foreseeably harm somebody. For example, driver has a duty to follow traffic laws, all the laws of the traffic to avoid any harming any pedestrian or other drivers, etc. Or a doctor has a duty to provide a standard level of care in diagnosis, treatment, avoid injuring the patient. So, duty of care is something very, very important. Just give me a moment. So, that is where it's a duty uh, of care which has to be taken care. For example, take a case law which is called Caparo Industries, CAPARO, Caparo Industries PLC versus Dickman, 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 1990. The court outlined that the criteria for establishing a duty of care, ruling that a duty exists when harm is foreseeable. So a duty exists when there is a harm which is foreseeable. So there is a relationship of proximity and it is fair, just and reasonable to impose a duty. So the person has to be then uh, penalized for that. Or the duty of care exists in the medical settings also. And these cases happen a lot. For example, uh, a duty of care is not taken, as I mentioned earlier in some other day, that somebody operates somebody and leaves some instrument or a towel inside the patient's stomach. It's a duty of care of the doctor to ensure this doesn't happen. So that is has to be taken, or a nurse who is under who's supervising some patient's health in the hospital or at home, and she does not take a proper care, and the patient goes through something which is endangering his life or loses his life, then this is a loss of duty of care which has happened. Another thing uh, is duty to care and its breach also. So breach of duty, what happens? So failing to uphold the standard of care expected in a situation is breach of duty. So you are not putting the duty up to the level or the standard what it is expected to. And you are doing it, but you're not doing it up to the level, up to the mark. Then it's a breach of duty which you have done. For example, a store owner fails to clean up oil which is on his floor timely manner, or a restaurant owner who is not cleaning, or a hotel owner who has not cleaned his bathroom properly and somebody goes and slips and breaks his head. So these things are people are toppling and breaking their bones. Or a surgeon, again a medical, these things are happening, are considered a lot into the medical context also, operates on a wrong side. So he has done his duty for coming and doing the surgery on time and whatever, but he is done on the wrong side, which is a clear breach of professional standard. So breach of duty happens because you have failed to uphold the standard of care as expected in a situation. So upholding the right level and quality of care is something which is, if not done, is breach of duties. Why duty of care is, you have legal obligation to avoid those acts that could forcibly harm somebody others. So negligent, you have been negligent. While breach is you're doing it, but you're not doing up to the standard of care which is required. So famous case law is uh, Blythe, BLYTH, Blythe versus Birmingham Waterworks Company. Birmingham, 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 Birmingham Waterworks Company, 1856. The court held that the defendant was not liable for damage caused by an unusual occurrence that could not have been foreseen, establishing expectations for standard care. So, in this matter, the damages were caused by uh, while some service providers from the waterworks were doing some repairs, and then there was some water which was spilled and that caused an accident. but it was an unforeseen condition, and there was although also standard conditions, standard care taken by the company, but because of some unforeseen conditions, the water spilled, and that's why the defendant was not liable to pay. But then in this case, the matter of discussion of breach of duty and upholding the standard of care is something which is expected, was the subject of the matter. Then another term is foreseeability under point two, foreseeability. We have spoken about it earlier in previous chapter also, but the ability to predict potential harm resulting from one's action. For example, a child running into the road while playing makes it foreseeable that a driver must be attentive to prevent an accident. Accident can happen from both the sides. If you are going through a, a locality which is full of kids playing on the street, it is your responsibility to foresee that accident might happen, and you should drive safely. Or a manufacturer who is producing products, he should foresee that if he puts very sharp edges, which is very dangerous, can put serious injuries also. So that is also, if causes a injury, it was foreseeable, and it was good care was not taken, and then it's a tort. So the very famous case is Andrews versus United Airlines. Andrews versus United Airlines INC 1994. And in this matter, the court said that a forcibility is a key element in establishing negligence, particularly in airline safety related causes. And as the airlines had not foreseen intentionally those things which might harm their or injure any a passenger, that is something which was supposed to be foreseen by the airlines, and this has contributed into the negligence injuring the passengers. So this was the case law. Next point is causation, which is, I'm just touching up quickly because we have already done this in previous chapter. Causation is establishing a direct link between the breach of duty and the injury caused. So this is the thread which connects. We talked about it, I think, a day before yesterday only. So a driver runs a red light and causes an accident, leading to injuries to another driver. Now the causal link is clear, that the driver negligent was directly resulted into the injury. So it has caused the another action which was initiated by another action previous to it. So, or a factory's improper disposal of chemical waste leads to a community health issue. So one action leading to another action which has did a bigger trouble to the people, and that is what is the causation is. So there is a direct link between the breach of duty and the injury caused. There was a breach which has happened because standard of care was not up to the mark, and that is why it's an example of causation. So famous case is Morris versus Harnett, Morres, Morris versus Harnett, Harnett, 1963. The court affirmed in this matter that the causal link between the defendant's negligence and the plaintiff's injury must be clearly established to warrant compensation. In this case, the plaintiff injuries were not sufficiently linked to the defendant's action, so the defendant was allowed to go in this matter. But in this landmark judgment, Morris versus Harnett, there was a link of connection between the breach of duty and the another action which was done, which is causing an injury later, was established. Now, what could be the defense in such cases of negligence? So, defenses could be, as spoken earlier, also contributory negligence. So, that a plaintiff's own negligence contributed to their injury, which can reduce or eliminate the recovery. So, it was the plaintiff himself or herself who was negligent. For example, a pedestrian does a jaywalking. Jaywalking, you know, right? You cross the road from anywhere, any place, without even thinking, looking into the signal or the vehicles coming and going, and you are just walking abruptly on the road, which is jaywalking. So, pedestrian jaywalking gets hit by a car. He was jaywalking, he gets hit by the car. So, if the pedestrian was partly to blame for the accident, the damages awarded may be reduced based on the degree of their contribution to the risk. It always happens in the Motor Vehicle Act because the contribution of accident is mostly from both the parties. If that happens, both the parties have their contribution or share into that particular situation, what has happened. Or a cyclist riding without lights at the night and gets injured in the collision with a car which is coming from other side. He was not visible in the night. He was wearing black dress, a black cycle, and no lights. He had contributed to the accident. Um, the Gordon versus East West Railway. Gordon, Gordn Gordon versus East West Railways, 2008. In the situation, in this matter, the court decided that the plaintiff's actions were ignoring warning signs resulted in contributory negligence. So he tried to cross the railway line. He tried to uh, pass from the place where it was allowed to pass, although, but then there was warning signals given. There were lights which were given. There were boundaries. The poles were put there, and the person ignored those things and still crossed the line, injuring himself. So that is where he contributed to the negligence. Then another defense is comparative negligence. So damages to be awarded in proportion to the level of fault assigned by each party involved in the accident. So if I am also involved, if I have also contributed, I can take also defense of comparative negligence and reduce my share of compensation as a defendant. So if an accident where both the drivers contributed, if one driver is deemed to be 70% at fault, other driver is deemed to have 30% fault, the damage award to the will be lessened by 30%. So whatever the proportion the court believes, if in that proportion, that particular amount of that particular amount is reduced because the person has compared is in a comparative negligence situation contributing to the accident. And the famous case law is mm, Lee versus Yellow Cab Company. Lee LI versus Yellow Cab Company, 1975. This is a Californian Supreme Court decision where the right to recover damage is in proportion to the fault under the comparative negligence rule. So the person, if sitting in the car, uh, has a damage because the car driver has not driven properly or the car was not fined from the taxi company and the accident happens, you also contribute by not wearing the seat belt. If you are supposed to wear a seat belt, so that proportion of injury which could have been lesser, which is now more because you have also contributed there. So the comparative negligence is counted and the compensation is made lesser in terms of the doctrine of comparative negligence. Assumption of risk, we have talked about it. So if there is an assumption of risk also, then also the very same thing. Let's talk about occupier's liability. So this principle holds property owners and occupiers legally responsible for injuries sustained by visitors due to dangerous conditions on their premises. For example, a visitor slips and falls on the wet floor in a grocery store. If the store failed to place a warning sign, they may be held liable due to neglecting their duty to maintain a safe environment. If you see in the malls, if you go to the malls or a grocery shop or a big merchandise shop, they keep always a signage there, caution wet floor. Why do they invest that money in that? This is why. Because it's an occupier's liability that the principal who holds the property, owns it, manages it, occupies it, is legally responsible for injuries sustained by visitors due to dangerous conditions on their premises. And that is why they are putting all those signages every time. That is not my will. Otherwise, nobody would have bought that. So famous case law is Wheat versus Lacon, WHEAT Wheat versus Lacon, LSU and Lacon, 1966. The House of Lords ruled that the landlord was liable for injuries to a tenant caused by unsafe premises and emphasizing the importance of maintaining a safe environment for visitors. If you have not put right setting for your visitor to come and use the premises by your wish within there, being you being the owner, anything which is caused by your negligence, which is causing somebody else an injury, your visitor, is an occupier's liability. You are supposed to pay for that. So tomorrow, if one of your friend comes to your house and falls down in your property because of something you had dangerously kept or not maintained, then you are liable to pay for their damages for their health. Now, the last topic in this particular part in this section is um, res ipsa loquitur. So this doctrine allows negligence to be inferred from the very nature of an accident. So the negligence has to be understood from the very nature of the accident, where the circumstances imply that negligence occurred. So this is something which helps you to determine what was the negligence and up to what extent, and was it there or not. So this is something which allows a negligence to be inferred. So you infer seeing the corresponding what has happened, how the accident has happened, what was the result of the accident, how it actually happened, and where the circumstances imply. So in those which circumstances it has happened, that the negligence has happened or not. For example, if a surgical instrument is left inside a patient after surgery, the event itself suggests a negligence, because this event of surgery and opening the patient, doing the operation, stitching back, in this whole uh, activity, in the very nature of this particular it shows that it's a negligence. Part of the surgical team is very negligible. The court may rule that the mere occurrence of the event indicates that a lack of proper care and management was doing during the surgical process. Or a previous example which I given earlier is a delivery truck causes a significant accident by losing its cargo in the middle of a busy road. The accident might imply negligence because a property secured load would not fall off and create danger for others on the road. So it was his duty to ensure it was locked properly, kept properly, balanced properly, and it was driven properly. So that is something again where by seeing how the accident has happened, how the result has happened, by in the it is inferred it is negligence or not, and where the circumstances will show that. So it is inferred from the very nature of the accident. The very nature of the accident is the load is dropped, and the circumstances show that the negligence occurred. So that is very, very important. For example, you see the metal rods or the different metal articles or bamboo sticks which are kept on the trucks or the tempo traveler. You see they put a lot of red flags, etc. It is something which, if accident happens, then how you have taken care is something which is very, very important. So very famous case law is Byrne versus Bodley, Byrne, Byrne versus Bodley, Boadle, Bodley, 1863. So the court ruled that a barrel falling from a warehouse. So there was a warehouse from there, a lot of barrels were kept. A barrel falling from the warehouse injured a passerby who was passing by, was enough evidence of negligence, because by the shape of the accident, it shows that there was a negligence, the design of the accident. So under the doctrine of res ipsa loquitur, the nature of the accident implied that the proper procedure were not followed. Or another example, case law is Scott versus London and St. Catherine Docks Company. Scott, SCOTT, Scott versus London and St. ST Catherine Docks Company, 1865. In this case, the court hold that when a heavy object falls from a dock and injures someone, the injury implies the duty of care was not met, supporting the use of res ipsa loquitur as the basis for negligence. Now we come to the point 3, which is liability of driver and owner under Motor Vehicle Act under 1988 for motor accidents. So the Motor Vehicle Act 1988 lays down a guideline for the operation of vehicles, how will they operate, the addressing all the liabilities which will occur if the vehicles are applied on the roads and in the event of accidents, and sets safety standards also for the road traffic in India. So it does all these things. It operates how guidelines on how to operate the vehicle, what is the liability, what are the safety standard, how the traffic has to be managed. All those things are taken care by this particular Motor Vehicle Act of 1988, and it includes provisions regarding the liability of drivers and vehicle owners for accident and the ensuring compensations. For example, let's talk about the first topic, which is liability on fault basis. I mean, we have studied this earlier also, but now we'll read it in context of the Motor Vehicle Act. So liability on fault basis, which is negligence. So under this framework, a compensation is primarily determined through establishing fault based on negligence. If the driver is found negligent, they can be held liable for the resulting damages. Driving from the reverse side, he has been negligent. Driving recklessly, being negligent. Driving after drinking, being negligent. So driver who's texting is negligent. So for example, a driver who's texting while driving runs a red light and collides with another car coming from some other side. So the injured party can file a negligence claim against the driver for all damages incurred to him from the medical expenses, etc., etc. Or a taxi driver fails to yield to the pedestrian traffic while making a turn and hits a pedestrian. The driver can be held liable for medical cost, other damages due to negligent driving and running his car over the pedestrian. So the famous case law is Nadia versus Muhammad Karamat. Nadia, NADI, Nadia versus Muhammad MOHD Karamat, KARAMAT, Muhammad Karamat, 1991. The court upheld that the driver was negligent for failing to keep a proper lookout and he was not taking necessary precautions while navigating traffic, resulting in the accident. So he went ahead in the traffic, he was not looking properly, he was not properly driving, and he was not taking proper precaution to drive through a traffic, and which resulted into the accident. So that is where Nadia versus Muhammad Karamat 1991 is one case law. Second one is Sukhvinder Singh versus Union of India 2002. So in this case, the respondent won the case, and the judgment emphasized that when you talk about a negligence of a driver, the plaintiff must show that the driver failed to adhere to traffic regulation. If it is not shown just by calling out it's negligent, it cannot be ruled against the driver. So both the case laws are there in way one where uh, the first one where the driver, it was against the driver, and second one it was for the towards for the driver. Now, no fault liability, which is section 140 to 144. So in no fault liability, basically the framework ensures that the compensation can be claimed regardless of fault or negligence, streamlining the claims process to support accident victim. For example, a pedestrian is struck by a speeding motorist who flees the scene under the no fault provision. The victim can claim compensation without needing to establish fault from the motorist. So that is how the insurance claims happen. It's on no fault basis. It's a third party insurance. A cyclist is injured in a hit and run incident. The victim can claim fixed compensation under section 140. So let me read the sections for you first of all. So we'll first go to section 140. So section 40 says the liability to pay compensation in certain cases on the principle of no fault. So this is all 140 to 144, all lies in chapter number 10 of Motor Vehicle Act, which talks about liability without fault in certain cases, which is no fault liability. So the section says where death or permanent disability. So section 140, subsection 1. So where death or permanent disability of any person has resulted from an accident arising out of the use of a motor vehicle or motor vehicles, the owner of the vehicle shall, or as the case may be, the owners of the vehicle shall jointly and severally be liable to pay compensation in respect of such death or disablement in accordance with the provision of this section. So this section is about jointly or severally being the responsible for the claim. Now, the subpart 2 says the amount of compensation which shall be payable under the subsection with respect of the death of any person shall be a fixed sum of 50,000 rupees, and the amount of compensation payable under the subsection in respect to the permanent disablement of the person shall be fixed sum of 25,000 rupees. Now, if any claim for compensation, point 3 says, if any claim, in any claim for compensation under subsection 1, the first one, the claimant shall not be required to plead and establish the claimant, which is the person who has met the accident. So the claimant shall not be defeated by the reason of, sorry, be required to plead and establish that the death or permanent disability in respect of which the claim has been made was due to any wrongful act, neglect, or default of the owner of the vehicle or vehicle concerned or of any other person. So there is no negligence which has to be proved. The act has happened of injury or death, that is sufficient. And that is why you need insurance, because whatever we are reading right now is falling on the shoulders of the owner of the car or the owners of the car or that vehicle. So it falls from the owner's shoulder to the insurance company who takes the responsibility. Otherwise, the owners would end up paying. Because in either way, whether it was negligent or not, you are supposed to pay. Point number 4 says, a claim for compensation under subsection 1 shall not be defeated by reason of any wrongful act, negligent or default of the person in respect of whose death or permanent disablement the claim has been made, nor shall the quantum of compensation recoverable in respect of such death or permanent disablement be reduced on the basis of the share of the such person in the responsibility for such death or permanent disablement. So in case of permanent disablement or death, the shares part is removed. So there is no share. We read about it in a few moments back, right? So the contributory, the share part is not considered and it is not required to be considered. And point 5 says, notwithstanding anything contained in the subsection 2. Subsection 2 talks about the compensation amount which is mentioned. Anything subsection 2 regarding death or bodily injury to any person for which the owner of the vehicle is liable to give compensation for relief, he is also liable to pay compensation under the any other law in the time being in force. So provided that the amount of such compensation to be given under any other law shall be reduced from the amount of compensation payable under the section 163. So basically, in nutshell, if you see, this talks about there is no liability to be seen from the perspective of negligence was there or not in case of accident, death, or permanent injury. There are certain amount which has to be claimed, and it does not matter if the person who was driving the vehicle was at a fault or not. In either case, the recovery has to be has to happen according to the law, and it is not, the cause is not defeated if the person was negligent or not. So end of the day, if there is an accident, there is a compensation in this case. Let's go to section 141. So 4 sections are there. 141. Now, provisions as to of other rights to claim compensation for death or permanent disablement. So provision as to other rights to claim compensation for death or permanent disablement. So the right to claim compensation, point 1 says, the right to claim compensation under section 140 in respect to death or permanent disablement of any person shall be in addition to any other right except the right to claim under the scheme referred to in section 163A, such other right hereafter in this section referred to as the right on the principle of fault to claim compensation in respect thereof under any other provisions of this act or any other law for the time being in force. Clause 2 says, a claim for compensation under section 140 in respect of death or permanent disablement of any person shall be disposed of as expeditiously as possible, and where compensation is claimed in respect of such death or permanent disablement under this section 140 and also in pursuance of the right of the principle of fault, the claim for compensation under section 140 shall be disposed of as aforesaid in the first place. Point 3 says, notwithstanding anything contained in the subsection 1, where the respect of the death or permanent disablement of any person, the person liable to pay compensation under section 140 is also liable to pay compensation in accordance with the right of the principle of fault. The person is liable to so liable shall to pay the first mentioned compensation, and if the amount of the first mentioned compensation is less than the amount of the second mentioned compensation, he shall be liable to pay in addition to the first mentioned compensation only so much of the second mentioned compensation as is equal to amount by which it exceeds the first mentioned compensation. And if the amount of the first mentioned compensation is equal or more than the amount in the second mentioned compensation, he shall not be liable to pay the second mentioned compensation. So this talks about add on to the section 140, talks about the amount of the compensation which the person can claim on various situations of death or permanent disability. And this is something which talks about if there are compensation made and if the previous compensation is lesser than the second compensation, the person has to pay that delta amount again, which is the difference of the second lower amount and the first amount. And so and so forth. If the first mentioned compensation is equal to or more than the amount of the second mentioned compensation by the court, then he shall not be liable to pay anything because he has already paid something which is more than that. So if 100 rupees was a compensation which was asked to be paid in the first instance by the court, which is the lesser number of amount, and in the later point of time 400 rupees was fixed as a compensation amount, 300 rupees has to be paid because it has to be made up to 400 rupees, which is the last compensation. In some cases, if there is a compensation of 400 which was already awarded, and then the court comes back and says a compensation of 200 has to be awarded in some later judgments, then there is nothing which has to be done. The person need not return back that money to make it lesser. So that's what section 140 and 141 says. Section 142 says is definitely all about permanent disability. So 142 is about permanent disability. So for the purpose of this chapter, permanent disability of a person shall be deemed to have resulted from an accident of the nature referred in the subsection 1 of section 140, and if such person has suffered by reason of the accident any injury or injuries involving permanent privation of the sight of either eye, or the hearing of either ear, or privation of any member or joint, or destruction of permanent impairing of the powers of any member or joint, or permanent disfiguration of the head or face. So either of these things are considered as a permanent disablement. So it has to be an accident which has happened. In negligence does not matter for the compensation. It might have lost either of the eyes, left or right, or both of them, or hearing capability has been lost, or any member or joint. Member means any limbs, legs or foot are members. So any of the members or any of the joints attaching them, if it is permanently disabled or broken, or destruction of permanently impairing the power of any member, permanently that person cannot use it now, either of the limbs, or the head or the face is completely disfigured. So for this no fault liability, when we talk about the permanent disability, a word is used. So permanent disability is defined here in section 142. 143 talks about applicability of chapter to certain claims under Act 8 of 1923. So the provision of the chapter shall also apply in relation to any claim for compensation in respect to death or permanent disability of any person under workmen's compensation. So if any accident which happens in the factory, then also this no fault liability is applied, which is defined in section 143. While section 144 says overriding effect. So the provisions of the chapter shall have effect notwithstanding anything contained in any other provision of this act or any other law for the time being in force. So this is overriding effect on anything which is time being in the law. So coming to no fault liability, we saw this 140 to 144, the sections. Famous case law is New India Assurance Company Limited versus Shantaram Sitaram Khamkar, 2007. So in this particular scenario, the New India Assurance Company, uh, where the company denied the payment, considering there is an element of negligence. And that is where, in the considering the no fault liability, the court came back and held that for to pay a compensation to the victim, there should not be an establishment of negligence. It's only as per mentioned in section 140, there is a negligence which has to be kept over, aside, and what is mattering is the accident, which is causing a permanent disability or a death. In those scenarios, we have to keep aside the element of negligence, because this is of a very serious nature and it has to be catered, and the insurance company has to pay. Structured formula basis, which is section 163A, 163B, and schedule. I will have to stop today here. I will take it further tomorrow because I have to leave my house at 10:05. So I will